items. The meeting is officially open. Welcome members of National Assembly and members of this committee. Welcome officials from Treasury, officials from Parliament, in particular the SCOF support team, media, if it's present, PBO, and other stakeholders. Are there apologies?
Good evening, Chair. The only apology is from Dr. George.
Okay, there's an apology of Dr. George, noted. Let's move to the business of the day. Item 2, a response by members, Honorable Liz, Honorable Kachalia, to submissions received during the public hearings on the Public Finance Management Amendment Bill, B41 2018, and the Public Finance Management Amendment Bill, B13 2020. In that order, Honorable Liz, you can take the stage and respond to the submissions. Then I will come to Honorable Kachalia after you.
Thank you, Mr. Chairman. Yeah, it's the submissions only just received the one from the legal services today during the sitting, so I haven't really had a good look at it. But it seems to me that that submission is slightly different from the National Treasury submission. Both submissions acknowledge the desirability of the proposals, but perhaps in terms of the National Treasury view, they shouldn't be included as a change to the bill. Whereas, as I understand it, the Parliamentary Legal Service has a slightly different view. So I'm sorry to do this, but perhaps we could get some sort of input from the two of them, Mr. Chairman, before we proceed, or is that part of the agenda? I haven't, yeah, you may be asking for that just after us, but I'd like to formulate my comment once, and certainly the Parliamentary Legal Service's input, I think, is valuable.
Alan, have we got Treasury and Parliamentary Legal Service to make short input?
Yes, Chair. Advocate Fana Merwe is for Parliament, and then Advocate Van Score for National Treasury. They're both online.
Okay. Shamin, there you are. 4 minutes, please.
Thank you, Chair. Chair, I did prepare a presentation. If I may share it, and I'll try to be as quick as possible, but it might be good for members to see the inputs. What we are talking to is the response proposals from National Treasury. So what our response is based, we need to start looking at what it is that both of these bills are trying to achieve. And just perhaps to clarify, this is not so much a submission by us. It doesn't provide the committee with a final answer. But there are some things that we felt the committee needs to be aware of when it makes a decision in respect of the mischief and the possible solutions to that mischief. So, Chair, in respect of Mr. Lees's bill, it deals with the issue of guarantees and the challenges that are there currently in practice related to guarantees. In respect of Mr. Kachalia's bill, this relates to the submission of reports and statements where there was a delay in submitting it. The entity indicated that they can't submit it, and then the Act is quiet on what must happen after that. So both these bills propose legislative solutions. The one indicates that there must be an extension of the oversight capability. The other indicates there must be a time period added to this report that is filed on why statements and reports are late, so that that is not the last step in the process. There will be a further 60-day process within which these must be submitted. Treasury's proposal, Chair, deals with saying that the mischief could be valid. The solutions proposed definitely require some kind of consideration. But Treasury is of the view that it should rather be contained through instructions. And here they are looking at Section 76 of the PFMA. And so what they are saying is that in respect of guarantees, there can be a Section 76 instruction that requires the minister to report quarterly. And in respect of the 60 days for submission of reports and tablings, there can be an instruction that sets that out. Now, just to confirm, I did speak with Treasury afterwards, after they submitted the document. The document indicates that the instruction could indicate that it gives 60 days within which the tabling of the written explanation must be done. But that is just an error in their proposal. What they are proposing is 60 days to table the instruments after the written explanation was filed. They also raised the concern that if there is a specific time period in the Act, it would lead to an issue of non-compliance. So that is what is before the committee. Then from our side, what we would like the committee just to be very much aware of, because what we are looking at here is primary versus secondary legislation as a solution. And first of all, we must keep in mind the legislative role of Parliament. There has been a lot of talk lately in Parliament about the role that Parliament plays, either through its committees or through its members in the development of legislation. And of course, we all know the Ambrosini case. It is up there, and members can have a look at that. But the big issue comes with the proposal for secondary legislation. And this is just where we would like to caution the committee in this regard. We inquired from Treasury exactly what in Section 76 would be used to do this instruction that is being proposed, because Section 76 does not specifically provide for regulations or instructions to be made in respect of either guarantees, securities or indemnities, or in respect of the time period for the submission of reports and statements. And the problem with that is once we adopted our constitution and we went for constitutional supremacy instead of parliamentary sovereignty, the way that we could delegate legislative powers as Parliament has changed. So with parliamentary sovereignty, Parliament could delegate the power to amend an act or to repeal an act to the executive. That has now changed. It is no longer possible because we must comply with the Constitution, and the Constitution gives Parliament plenary powers and requires, in terms of Section 74 to 77, how legislation must be prepared. So the concern that we just have is that we must be very cautious with something like this. It's called an omnibus regulatory power that is delegated to the minister. And the same will be in respect of the tabling of reports as in respect of guarantees. So on both bills, we must just be aware of this caution. There was also a comment that, Parliament can ask for these guarantees, for information and so on. But the committee needs to consider, where are we in this process? Why is this not forthcoming? And the fact that legislation, and again, talking to the legislative role of Parliament, the fact that legislation is one of the ways in which Parliament strengthens its own oversight function. When it comes to omnibus regulations, Chair, it is something that the risk there is that the executive may go broader than what was the intention of the legislature and might actually go tread onto the plenary powers of Parliament. So, and I've quoted a case there, but I'll leave it there, members can read in it. So the concern is just that there must be a lot of caution if we rely on instruction that will be issued on such an omnibus power. Because at the moment, if we look at what is happening in fact, both of the bills, there is no provision in the Act. There's nothing that can be expanded on by way of regulation or instruction. It will be something that is new. And the question is if that will not be something akin to amending the Act. And they are also given a case reference of Executive Council Western Cape, where the court made it very clear that regulations, or in this case, the instructions, which are also in terms of Section 76, must not do more than give effect to what is contained in the statute itself. We must also keep in mind that the Act does contain certain timeframes. So it appears that the intention of the legislature, and here, of course, I'm talking about Parliament, is to deal with these matters by way of legislation. So all of these are just caution in respect of instructions itself. Also, if the purpose of these bills are seen as to expand the oversight function and to make it more clear where further oversight reports, etc., are required, then by allowing the minister to prescribe how this oversight will happen could also be argued to compromise the principle of delegating plenary power. So Parliament is and there's another case just to say, it is for Parliament to look at that good governance in South Africa. And if we look at what a further proposal that was made, or rather mentioned in their proposal, was the power of the Minister of Finance in terms of Section 79 to approve a departure from the period that would be contained in such an instruction. And the question, of course, is if the minister can withdraw this instruction, if the minister can change the time frame, how does this impact on Parliament's oversight function? And who should allow this? Is the minister the correct person to allow this? What should be the further result of such an extension? There was also a concern raised by Treasury where they would propose different ways of dealing with the solution proposed in the bills. For instance, in the bill of Mr. Lees, instead of saying that it should be per instance, that it should rather be on a quarterly basis. But these are all things that can be amended in the bill. So these should not be something that is of concern to the committee. If the committee decides in the end, and this is where I'm ending, what is it that the committee must decide in respect of these private members' bills? In respect of Bill 41, the question is whether does Parliament want increased oversight in respect of decisions taken on guarantees? We understand that there is a challenge in respect of guarantees, but is this the solution that the committee feels is the most appropriate? Whether by way of instructions, whether by way of bill, whether by way of a third solution, that is the question, or the second question rather. It might even be that the committee says, but the problem is not so much knowing when the decision is taken or rejected. It is something else that we need to look at. But that is the question that the committee needs to decide. And then the same in respect of the tighter controls in respect of the late submission of reports. What I would like to just caution the committee on is if the committee decides that this must be done, that we do want this increased oversight on guarantees in respect of the decisions, and we do want the tighter controls in respect of late submission of reports, then we must be very cautious that we do not rely on instructions that might interfere with the plenary power of Parliament. So, Chair, that is what we would like to convey to the committee. It doesn't provide an answer, and unfortunately, that is the nature of legislation. There's a lot of decisions to be made around it, and most of these are policy decisions that we can't advise the committee on. But I hope that was of assistance to the committee. Thank you, Chair.
Thanks, Charmaine, for your input. Ms. Van Schoor, over to you.
Thank you very much, Chairperson, and good evening, other members of the committee. Yeah, I'll be short. I think the first point that we need to make is that these are existing powers that's in the PFMA that was passed by Parliament, and it's a post-constitutional law. It's not a pre-94 law. But we understand we must apply these powers in accordance with the Constitution. Our view is that the minister or the delegated authority, because the instructions are generally issued by officials within Treasury, or if another option would be to issue regulations under the same provision, that it's possible to regulate guarantees further, because it's currently provided for in the chapter that the bill seeks to amend. And it also deals with the general powers linked to what Treasury needs to enhance transparency. As to the power on relating to the tabling of reports, that in our view can also be linked to transparency, and they, in terms of ensuring that Parliament receives these reports, and that there's not then currently there's no provision as to when it should be tabled once a written explanation is provided. So, but as to the option whether this should be in prime legislation or in subordinate instruments, whether it's regulations or instructions, that is for the committee to decide. But in our view, it's permissible, it would be permissible to make these instructions. In the case of the annual reporting one, we did, the reason we put in the letter why we said there should be a possibility of approving a departure was the example that we gave of the unrest last year, where it was impossible for the EA to table on time. So it's not the doing of the EA, the lateness, and there should be the scope for that kind of possibility, and that it's easier to do that through instructions. And in the case of guarantees, that the reporting on guarantees considered whether approved or declined, there's also provision for indemnities and securities, and we're concerned about applying it so widely, because indemnities and securities appears in many commercial type of contracts for goods and services. And then again, in that case, it could be regulated through the instruction that could be adjusted as required. And then just to note, the power to coming back to the possible departure to be that Treasury may approve in terms of 79, that any such departure must be reported to the Auditor General. It's currently in the PFMA. So there is that provision, and obviously the Parliament can also require Treasury to report on such departures approved in relation to annual reporting. Chair, that is from my side. Thank you very much.
Thanks, MP, for the input. Mazamban, can we come back to you?
Yeah, sure. Thank you very much, Mr. Chairman. And thank you to Charmaine and MP for the input. It is indeed very useful, and it does, I think it should help the committee to make a decision. Let me just, Mr. Chairman, say that in the current way that we operate, there's a comment made that we can ask for it. I think Charmaine said we can ask for this information. Certainly we can ask for this information. But my experience, and I think the experience of many of us in Parliament, is that the information frequently takes a long, long time to come back, replies to questions, and frequently there's fudging, obfuscation, and one doesn't get the clear answer. And so I really do think that that's not the solution to the mischief. And then in terms of using secondary legislation, instructions or so on, that takes it again and puts it in the hand of the executive or National Treasury. And that again is an issue because it's up to them to decide whether or not to issue the instruction. And we've seen that there is a mischief. I think every one of us accepts that the mischief is real. But I don't believe Parliament should rely on the executive or officials delegated to make decisions about how this mischief should be dealt with on an ad hoc time-to-time basis, because these regulations and instructions can be changed. So let's assume that as a result of these bills being put forward and possibly being put aside on the basis that instructions will be used, well, and National Treasury and the Minister do the right thing and issue the instruction. In 6 months' time, what happens when they say, no, we don't think this is the right instruction anymore? I really do believe, Mr. Chairman, that this must be embedded in the legislation. And clearly, Charmaine has pointed out that there is no problem with doing that in terms of the Constitution and the legal aspect. So if that is the case, then I would suggest to you that that's where it should reside, in the primary legislation. Now, if there are certain amendments that would make it work better, I'm open to considering those amendments. And I'm a little disappointed that those amendments aren't coming forward. There seems to me, Mr. Chairman, to be a wish not to have it in the legislation on the part of National Treasury. And therefore, we'll find arguments why it should not, but not arguments why the mischief doesn't exist, and therefore we actually wasting our time in Parliament. So in closing, Mr. Chairman, I would say to me, I am convinced even more now that it should be a part of the Act and not an instruction or a regulation. But if there are really cogent amendments, I will certainly consider them. I have no problem with that, and the committee must consider them as well, as long as we deal with the mischief. So, Mr. Chairman, I would urge the committee to either say we're going ahead as it is now, or we're going to give National Treasury or whoever wishes to propose some amendments for us to consider. I'm not sure that Charmaine or Frank can guide us on how the procedure works with amendments. Would I have to propose the amendments, or would someone on the committee have to come out of Parliament, and what I'm saying, rather than from the executive? But that's a formality I'm sure we can deal with. So, Mr. Chairman, in closing, I just want to thank you for dealing with these bills. I'm so encouraged that these mischiefs are going to be dealt with in one way or another. So thank you very much.
Thank you. I believe that it can't come from Treasury because they are the executive. This is a private member's bill, and your assistance is the Parliamentary Legal Services. But let me get Advocate Jenkins. I see his hand.
Thank you, Chairperson. Good evening, honourable members and my colleagues. Chair, yes, the committee has this bill now. So the amendments to tighten this bill up or to change it would be for the committee to decide. So the amendments will come from the committee, not necessarily the political sponsor, Mr. Lees and Mr. Kashalia. So we can, and my colleague Charmaine van der Merwe will assist with that if it's necessary. Chair, if I may, just quickly, Chair, I just want to point to the committee that the Money Bills Amendment Procedure, Chair, in 2009, that was the first time that Parliament actually took a stance on the issue of state-owned enterprises. And we required there that the strategic plan, annual performance plan, and the budget must come of entities, must come to Parliament prior to approving those budgets. The PFMA didn't provide for that. So there was a gap Now, Chair, that was fixing a mischief. The NDP, the National Development Plan, highlights the non-performance of SOEs and the draining of the fiscus or because of guarantees on the SOEs. And all I want to say to the committee is Parliament should not be blindsided any longer by the by what's happening with guarantees and so on, because Parliament has been, and that has been pinpointed in the National Development Plan. So that is something that needs to be considered. So these matters are actually much bigger than I actually even thought at one stage. So Chair, the issue of remedying the mischief, I just want to say from a legal point is necessary. There is a lack of oversight over the SOEs from Parliament side, and we see it in the Zondo Commission's report, and we saw it in the National Development Plan. So Chair, is within that context that I think there should be a discussion between National Treasury, the committee, and the members on how we're going to fix this mischief, Chair. Now, this is not something that I could not say. Thank you, Chair, for the opportunity.
Okay. No, thanks, Advocate Jenkins, for that clarity. Let's move to Mr. Kachalia. Over to you, Honorable Kachalia.
Yes, Chair, apologies for coming in late. I just finished in the House and I've just literally got to my desk here. I received the letter from National Treasury. Just for information, my initials are GKY, not GKU, so they need to fix that. But over and above that, I understand that the comments and that there is a, that there's a willingness to incorporate into the PFMA. However, the recommendations that are presented in the letter from National Treasury, in my view, continue to leave loopholes which this bill was trying to close. And I don't know in terms of process what I should do. I'm prepared to pen a response. If you advise who I should send that response to you, the chair, or to Treasury, or to send it to you and copy Treasury, or the other way around, I'd appreciate advice. And if then my recommendations are met in terms of the way they vis-a-vis what is proposed, the changes that I might recommend, then I'd be happy for it to be part of the new PFMA, if you like. But if not, then I would wish to take it to the National Assembly. So I'd appreciate advice from the chair.
Okay, Honorable Kachalia, I thought I had Advocate Jenkins saying that the bill now is before the committee. So if there has to be responses or amendments, they have to be done by the committee. Maybe let me get Charmaine and Advocate Jenkins to clarify your question.
Thank you, Chair. Yes, in fact, the bill is now before the committee, and the rest of the process is now that it is for the committee to consider a motion of desirability on the content of the bill, or both bills, apologies. Once the committee has decided whether the bills are desirable or not, if not, the committee will report to the House. If the committee decides they are desirable, then the committee can do its own call for comments. It can do a further public participation process. The committee can make proposals to add to the bill, to change things to the bill. So it's 100% the same as an executive bill from there, or rather from here on out. And it's only once the committee has made a decision that the bills will go back to the National Assembly, whether that decision is to not adopt a motion of desirability, or whether the committee adopts a motion of desirability, deliberates on the bill, and then adopts a bill. That is the only times that the bill will go back to the committee. Otherwise, it is firmly before this committee to consider. Thank you, Chair.
Thanks. Before I come to Honorable Mrolo, what I should indicate is that tomorrow, 9 o'clock, we are going to meet to consider the motion of desirability on both bills. So that's how far we are in processing the two bills. So if there has to be amendments, it has to be tackled at that stage. Thanks, Charmaine. Over to you, Honorable Mrolo.
Thank you very much, and good evening to yourself and members of the committee and all colleagues in the platform. Are you suggesting that the matters that are before us today can be ventilated in the morning, Chair? Is that what you are suggesting? Or that they should be ventilated now and tomorrow we should only consider the motion of desirability?
If there are issues that you would like to raise, you can do so. Tomorrow we will still have a platform, because tomorrow we don't just vote. Even before we vote, if you remember, we do deliberate. But if there are issues that you want to raise, you can do so. And tomorrow morning also, you will be allowed to do so. If you agree, no problem. If you don't agree, for instance, tomorrow you will have to motivate why don't you agree with the motion. So, but it's over to you. Back to you, Honorable Mrolo.
No, Chair, I will take full advantage of the opportunity given to me tomorrow to express my disagreement with both bills, proposed private member bills. And so, yeah, I'll take advantage of the opportunity that will be presented tomorrow to do so.
Okay, that's the only hand I can see now. Is there any other member who would like to make a comment or ask a clarity-seeking question before we move to the next item, because we'll meet again tomorrow morning? Skozan, Mhlonishwa.
Yeah, no, thank you very much, Honorable Chair, and greetings to everyone. Yeah, I just want to find out just one issue, I think from both Honorable Liz and Honorable Kachalia, because when you look at the responses from the National Treasury, there seems to be a suggestion that when this proposed amendment, they could be easily be covered if they are, I think, if they come as part of amendments of regulations, as opposed to be part of the principal act. So I did not get clearly what is their position with regard to that. Well, I had Mr. Lisi, I think, emphasizing that he would like to see the amendment of the principal act itself. But I don't know as to, just to get clear the reasons as to what are the difficulties if these amendments, I think if we were perhaps as a committee to agree to them, but we say let them be part of legislations, part of instructions that can be given, as opposed to them being part of the amendment of the principal act, and taking into account the fact that there is a process of amending the PFMA, which is underway by the National Treasury. So are we not, perhaps, if we say we agree to this amendment to be part of the principal act, are we not later going to have a problem when going to the rules, taking into account the rules of the National Assembly, to say now we're coming back again in the near future, within the next 2 years before the end of this term? Now we come back as a committee with the proposed amendment of the PFMA, which will touch the number of different clauses that we are going back again to the National Assembly to seek amendment of the PFMA as a committee. I think if we're looking at putting the proposed amendment in these two private members' bill to be part of the Principal Act, can't we perhaps wait for that, the process of the National Treasury, so that we then also include them in the overall amendment of the PFMA, just to run away from the risk of us being accused by the National Assembly of bringing pieces of amendment of the same act within a very short space of time? Is there a difficulty from their part in us, perhaps as members, agreeing to this amendment, but for them to be part of regulations as opposed to be part of the principal amendment? Or if they insist on them being part of the amendment of the Principal Act, do they have a difficulty for us to say, let's wait and incorporate them in the process which is underway by the National Treasury to make amendments to the PFMA? That's my question, Chair. Thank you very much.
Siyathokoza Mhlonishwa. Honorable Abraham, then Honorable Sarupen.
Yes, Chair, I think as the ANC, we do want to move towards a motion of desirability. However, we also agree with Advocate Jenkins that it is the of the member or the owner of the private bill to make the necessary amendments as suggested by both Treasury and Parliament. For instance, in terms of the time frames for the reporting of the executive to Parliament, yes, time frames have been there, but the member seems to want to say that let it be 30 days in terms of instead of quarterly. And I think that is an area that the member needs to consider so that we can move together towards desirability. And the second one, for us as the party, for example, the issue of guarantees, indemnities, and securities, they are different matters and they need to be separated. Now, Chair, we want to move away from the 30 days as proposed by the member. Rather, let's stick to the quarterly. Chair, we do not want litigation to affect us all as a committee, because the entire amendment bill cannot be agreed upon. However, the urgency and the significance can be further and clearly explained by the member, so that all of us are taken on board, so that come tomorrow we are all in agreement and know what needs to be done. Chair, we take it that Honorable Liz, the fact that he was even prepared to have the National Treasury drafting the amendments for him, we take it that he is agreeable to changing some parts of his amendment bill, so that all of us can go forward in the same understanding, so that we can agree to move for a motion of desirability. I thank you, Chair.
Thanks, Honorable Abraham. Honorable Sarupen.
Thank you very much, Chairperson, and thanks for the opportunity. Just with regards to these two bills, Chair, I think that there is definitely an opportunity for the various interested parties and affected parties, National Treasury, Parliament, the committee, to find each other and address what is effectively lacuna in legislation. The opportunities that presented itself during state capture was also as a result of the gaps that existed in legislation. And I think we have a golden opportunity to plug those gaps. Even if further amendments to PFMA come up in future years, I think that the demands on the fiscus right now and the public demand for increased transparency means that we have to take this opportunity And I think none of the parties involved are disagreeable on this matter. I think we all want to see the lacuna addressed, and the fact that these circumstances were unforeseen and taken advantage of by elements of none of us ever anticipate. And I think that we can actually make something happen here. So I think we should get a proper briefing on the process tomorrow as to how to amend the bill and what would be required from there, so that we can also make an informed decision on the motion of desirability. If we proceed tomorrow and then are able to amend the bill thereafter, I think we should take the opportunity. Thank you very much, Chairperson.
Thanks, Honorable Sarupen. I think the legal services has clarified that National Treasury has made its input. You'll remember last time there was no written submission from National Treasury. And we made a call to National Treasury to make a submission in the written form, and they've done so. So as an interested party, it ends there. So if there has to be an amendment to the bill, it can only be done through this platform, because a private member's bill is treated the same way as the bill coming from executive. And the legal team of Parliament, Charmaine Jenkins and others, are the resource that are used by the member to draft the bill. And if ever we are agreeable to amendments, I think there will also be the same team that will assist with those amendments. But let me allow Charmaine and Honorable Jenkins to clarify that before we move to the next item, so that I don't talk in general terms.
Thank you, Chairperson. Yes, you have it absolutely correctly. So, of course, if the bills are not deemed to be desirable, the content of the bills not desirable, that would be the end of the process in respect of these two bills. We will then not consider amendments to it, because the content of the bill would not be found to be desirable. If the committee decides that one or both of these bills, their content is in fact desirable, it is then that the committee can consider amendments to it. And the public can make proposals for amendments, the department can make proposals, the members can make proposals. But of course, it is for the committee to decide what will these amendments be. And yes, our office will definitely assist the committee to make any such amendments that the committee may wish. Thank you, Chair.
Thanks, Charmaine. That's the case, Mazamban. Do you still have any point to make or clarity seeking with the legal services before we move to the next item? And Kachalia.
Mr. Chairman, I don't have anything to add, except, I mean, the question was put, why not allowed to be an instruction? Why not wait for the PFMA amendments? And I think those are valid questions, in the sense that the PFMA amendments by MP had told us even last meeting that they would probably take at least 2 years. Our experience is that these kind of major amendments to acts take much, much longer than that. So, and there's an urgency here. We heard even Advocate Jenkins Frank indicating the kind of lacuna that's there. So that's why we don't believe it would be the right thing to do to wait. And then secondly, in terms of allowing either the minister or officials in National Treasury to actually decide whether or not to issue instructions, withdraw instructions, etc., would not deal sufficiently with the mischief. We believe it should be in the Act. In terms of amendments, again, I repeat, if the amendment makes it possible to get consensus, and it obviously doesn't change the objective of the bill, I'm certainly, I can't speak for Honourable Kachalia, but I would be very happy to consider it, because I really do believe it's urgent that we address this mischief. So thanks very much, Mr. Chairman.
Thanks, Honourable Liz. Honorable Kachalia, any comment?
I concur with my colleague, Honorable Lisa's approach. Thank you.
Okay, thanks very much. Let's move to the last item, that is, I think it's closure, if I may. Alan, we're done with the interaction by the committee. We're at item 4. Is there any announcement before I make closing remarks or adjourn the meeting?
Chair, just as you mentioned earlier, the committee meets tomorrow morning from 9 to 10 to consider the motion of desirability on both bills. I'll send the link immediately after this meeting, and then also it's another 6 o'clock meeting tomorrow evening with a select committee on finance. Thanks, Chair.
Okay, thanks, Alan. Thanks very much, honorable members, parliamentary support team, treasury, for your input. Let's adjourn the meeting and meet again tomorrow at 9. Good night.
Thank you, Mr. Chairman. Good night, all.
Thank you, Chairperson. Good night.
Recording stopped.
Good night.
Thank you.